Good day everyone. Our report for today is about marriage and family. Marriage and family are key structures in most societies. While two institutions have historically been closely linked in Filipino cultures, their connection is becoming more complex. The relationship between marriage and family is an interesting topic of study to sociologists. What is marriage? Different people define in different ways. Not even sociologists are able to agree on a single meaning. For our purposes, we will define marriage as legally recognized social contract between two people. Traditionally based on a sexual relationship and implying permanence of the union. And creating an inclusive definition, we should also consider variations, such as whether a legal union is required. Think of a common law, marriage and its equivalents, or whether more than two people can be involved. Consider polygamy. Other variations on the definition of marriage might include whether spouses are opposite sex or same sex, and how one of the traditional expectation of marriage to produce children is understood today. Views of marriage. Marriage refers to a permanent union between a man and a woman entered into the accordance with the law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution. Refers to the legally and formally recognized union of two people as partners in personal relationship. Historically, and in some jurisdictions, specifically a union between a man and a woman. Marriage is an intimate union and equal partnership of a man and a woman. It comes to us from the hand of God, who created male and female in His image, so that they might become one body and might be fertile and multiply. Though man and woman are equal as God's children, they are created with important differences that allow them to give themselves and to receive the other as a gift. Marriage is both institution and a sacred union because it is rooted in divine plan of creation. In addition, the Catholic Church teaches that the valid marriage between two baptized Christians is also a sacrament, a saving reality and a symbol of Christ's love for His church. In every marriage, the spouses make a contract with each other. In a sacrament of marriage, the couple also enters into a covenant in which their love is sealed and strengthened by God's love. The free consent of the spouses make a marriage. From this consent and from the sexual consummation of marriage, a special bond arises between husband and wife. This bond is lifelong and exclusive. The marriage bond has been established by God, and so it cannot be dissolved. In the Latin rite of the Catholic Church, the priest or the deacon, the two official witnesses, and the congregation, all witnesses, the exchange of consent by the couple who themselves are considered to be the ministers of the sacrament. In the Eastern churches, the sacrament is conferred by the priest, blessing and receiving the couple's consent. Permanency, exclusivity, and faithfulness are essential to marriage because they foster and protect two equal purposes of marriage. These two purposes are growth and mutual love between the spouses and the generation and education of children. The mutual love of a married couple should always be open to new life. This openness is expressed powerfully in a sexual union of husband and wife. The power to create a child with God is at the heart of what spouses shared with each other in sexual intercourse. Mutual love includes the mutual gift of fertility. Couples who are not able to conceive or who are beyond their child-bearing years can still express openness to life. They can share their germinative love with grandchildren, other children and families, and the wider community. As a result of their baptism, all Christians are called to a life of holiness. This divine calling or vocation can be lived in marriage, or in a single life, or in a priesthood or consecrated religious life. No one vocation is superior to or inferior to another. Each one involves a specific kind of commitment that flows from one's gift and is further strengthened by God's grace. All vocations make a unique contribution to the life and mission of the Church. The family arises from marriage. Parents, children, and family members form what is called a domestic church, or church of the home. This is a primary unit of the church, the place where the church lives in the daily love, care, hospitality, sacrifice, forgiveness, prayer, and faith of ordinary families. Sociologists are interested in the relationship between the institution of marriage and the institution of family because, historically, marriage are what create a family. And families are the most basic social unit upon which society is built. Both marriage and family create status roles that are sanctioned by society. So, what is a family? A husband, a wife, and 2 children, maybe. Even a pet serve as the model for the traditional Canadian family for the most 20th century. But what about families that deviate from this model, such as a single-parent household or a homosexual couple without children? Should they be considered families as well? The question of what constitutes a family is a prime area of debate in family sociology, as well as in politics and religion. Social conservatives tend to define the family in terms of structure, which each family member filling a certain role, like a father, mother, or child. Sociologists, on the other hand, tend to define family more in terms of the manner in which members relate to one another than on a strict configuration of status role. Family, a set of persons related by blood marriage or adoption living in the same household. Nuclear family and extended family. Nuclear, a parent or parents and their unmarried children living together. Common in industrial and post-industrial nations, the strengths and weaknesses of nuclear family. Strength: parents make independent, autonomous decisions. Parent-child bond is stronger, more geographic mobility. Weaknesses: fewer economic resources, weakened bond with their relatives. Most commonly, we think of the 3-generation household: grandparents, parents, and children, that exist in many agrarian societies, but this is not the only form of extended family. Extended: relatives living together who do not meet the strict definition of a nuclear family. May include the nuclear family, plus other relatives such as a nuclear family and an uncle, or may be relatives such as 2 adult siblings sharing a household. Most commonly, we think of the three-generation household: grandparents, parents, and children, that exist in many agrarian societies, but this is not the only form of extended family. Weaknesses: lack of autonomy for adult parents, as the eldest family member retain the most power, even in child rearing and economic decisions.
Now let us tackle about the forms of marriage. The first form of marriage is monogamy. Monogamy is when two people is married only to each other. Most often it is only one man and one woman. But in some nations, in some states in the US, monogamous marriage may be between two persons of the same sex. Another form of marriage is serial monogamy. Serial monogamy happens when an individual is married to one person at a time, so it is also monogamy, but has more than one spouse on his or her lifetime. This may be due to death or divorce. Polygamy is another form of marriage. One person legally has more than one spouse at the same time. There are cultures worldwide that legally allow polygamy than legally allow the monogamy, like in the US. However, most people worldwide has monogamous relationship than polygamy, because polygamy is more expensive and lonely. Those who have great economic resources can afford to practice it. Polygamy has two forms. The first form of polygamy is polygyny. Polygyny has one man and two or more women. Most common of the two due to the traditions of patriarchy and societal shortages of men due to war. After the Iran and Iraq War, Iran practiced a modified form of polygyny known as muta. It is sanctioned by some interpretations of the Islamic faith, but had fallen out of favor due to Shah's regime. Due to a shortage of men because of war, it was being encouraged. It is a temporary verbal contract between a married man and unmarried women. In a few cases, women have multiple temporary marriages to support themselves and their children. The majority, however, are long-term and mean that the man simply supports more than one household. It is important to remember that children born of muta marriages are legitimate. It was religiously sanctioned and practiced to rebuild society. Another form of polygamy is polyandry. In polyandry, one woman and two or more men, currently practiced in Tibet. In terms of practically, it makes no sense. There is no shortage of women in Tibet. However, it is embedded in cultural traditions. It is in an in-group or endogamous form of marriage, such that whenever possible, a woman marries a family of brothers. Now let us move on to the descent patterns. The first descent patterns is the patrilineal descent. A family's lineage is traced on the man's side of the family, common in most agrarian societies. Next is the matrilineal descent. A family's lineage is traced on the women's side of the family, common in hunting and gathering societies. The Jewish faith traces religious heritage through female lineage. The third patterns of descent patterns is bilateral descent. A family's lineage is traced in both sides of the family, common in industrial and post-industrial societies, although vestiges of patrilineal descent remain, such as the still relatively common custom of the children taking the father's last name. Now let us move on about the newlywed residence patterns. First is the matrilocal residence. The newlywed couple move in the bride's family, example in the Navajo. Patrilocal residence. The newlywed couple move in the groom's family. Example country practice is China and Vietnam. Next is the new local Neo-local residence. The newlywed couple move into their own. New residents separate from their side of the family. Example is in the US. Now the courtship and mate selection. So first is the endogamy or the exogamy. Endogamy. Norms requiring encouraging people to marry within their social group. Traditionally, this was to maintain skills and power within the society. Today, most people marry endogamously because we more frequently socialize with people similar to us in terms of race, class, and religion, and etc. In courtship and mate selection, there are also homogamy and heterogamy. In homogamy, choosing a mate with similar personality and social characteristics. Example, two extroverts who are both Catholic and enjoy the outdoors. Next is the heterogamy. In heterogamy, they choose a mate with the similar personality and social characteristics. They say opposite attracts. Example, a middle-class Protestant extrovert and an upper-class Hindu introvert. But note, homogamy is more successful in maintaining long-term relationships and marriage. So another is the exogamy. Exogamy is the norms requiring and encouraging people to marry outside their group. Traditionally, this was to bring in needed skills or to make peace with another society. Today, in societies where people choose their own mates for reasons of romantic love, there is an increase of exogamous marriages. However, endogamy is still the norm.
Modern trends in marriage and family. A. Singlehood. People are staying single longer. Average first marriage ages are later for both sexes, about 27 for women and 29 for men. In addition, there is some evidence that there is an increase in people who will stay single or never marry. Reasons are more opportunities for and more social acceptance of singlehood. Specifically, women are no longer viewed as old maids if they aren't married at 21. There is more tolerance of homosexuality such that there isn't the need to marry to hide one's homosexuality, and business are increasingly willing to hire and promote single people. Single parenting is also increasing. Approximately 40% of children are now born out of wedlock, a fourfold increase since 1970. This is not uniform by educational and economic background. However, among women with a bachelor's degree or higher, only about 10% are unmarried when they give birth. For women with some college but no degree, 40%, and 57% for those with a high school diploma or less. However, birth to teenage mothers have dropped dramatically by nearly half since 1991. Most unmarried mothers today are in their 20s and early 30s. B. Cohabitation. Living together without being married. It is also increasing, especially in industrialized nations. From 1996 to 2012 in the US, the number of cohabiting couples jumped almost 170%. From 2.9 million to 7.8 million, reasons are delayed age of marriage, increased social acceptance, and a desire to try out a mate prior to marriage. Until recently, when couples cohabited before marriage, their divorce rate was actually higher than couples who did not cohabit prior to marriage. This was not thought to be based on cohabitation. C. Dinks. Double income, no kids, people who are married, both employed and childless. Some chose not to have children, no more acceptable than in the past. Some delay childbearing and then have difficulty with conception. Economics also plays a role. According to the Department of Agriculture, the average middle-class American family in 2012 spent $241.80 to raise a child from age 3 after diapers, to age 18 before college, and whatever the reasons, the percentage of dinks is also increasing. Couples who cohabit tend to hold more liberal attitudes. Couples who do not cohabit hold more conservative attitude and believe more strongly in the importance of staying in the marriage. Even unhappy one, however, recent research by demographer Wendy Manning indicates that for couples in the U.S. who married since the mid-1990s, cohabitation is not associated with a higher risk of divorce. In some countries, like Australia, living together before marriage has actually become a protective factor against divorce. D. Adoption. The trend is from close adoption, where all records are sealed at the time of the adoption, in where access to adoption record is available to birth parents, adoptive parents, and the adoptee. The trend began with the need to access medical information or history of biological parents. There are many unresolved ethical and legal issues. However, if records are sealed, then opened, privacy violations occur. If prospective adoptive parents learn of medical problems in the child's family history, will they turn down the adoption? Whose rights are most important? The child, the biological parents, the adoptive parents? Finally, laws vary from state to state, and some people, or not all, are opting for totally open adoptions for the biological mother and possibly father and adoptive parents know each other and may even share visitation and custody rights. E. Gay marriage. In 2004, Massachusetts was the first state to legalize gay marriage. In that year, 55% of Americans opposed legalizing gay marriage. By 2013, 58% of Americans favored legalizing gay marriage, and support is strongest among younger Americans. At this writing, 36 states and the District of Columbia have legalized gay marriage, and while there is significant backlash, it is likely that number will grow. However, it will likely be some time before it is legal in all states unless there is a chance in federal law via Congress or the Supreme Court. F. Divorce. The U.S. divorce rate is the highest in the world but is declining. After remaining at close to 50% of first marriages for several decades, it began to fall in 1996. It is now about 40%. However, there are distinct education and social class differences, since one of the major issues in divorce is economic instability. For middle and upper income couples with college degrees, the rate is less than 30%. The majority of divorced people remarry. G. Egalitarian marriages. The share of mothers employed outside the home has quadrupled since the 1950s, and today, nearly three-fourths of women with children work outside the home. The number of women who are their families' sole or primary breadwinners has increased to 40% today from 11% in 1960. Cultural attitudes are adapting. 62% of all Americans and 72% of all adults under 30 view an ideal marriage as one where the husband and wife both work outside the home and share childcare and household duties.
Requisites of marriage. In Article 1, marriage is a special contract of permanent union between a man and a woman entered in accordance with law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage within the limits provided by this code. In Article 2, no marriage shall be valid unless these essential requisites are present. 1. Legal capacity of the contracting parties, who must be a male and a female. And 2. consent freely given in the presence of the solemnizing officer. In Article 3, the formal requisites of marriage are: first, authority of the solemnizing officer; second, a valid marriage license except in the cases provided for in the Chapter 2 of this title; and third, a marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. In Article 4, the absence of any of the essential or formal requisites shall render the marriage void ab initio, except as stated in Article 35, Section 2. A defect in any of the essential requisites shall not affect the validity of marriage, but the party or parties responsible for the irregularity shall be civilly, criminally, and administratively liable. In Article 5, any male or female of the age of 18 years or upwards, not under any of the impediments mentioned in Article 37 and 38, may contract marriage. In Article 6, no prescribed form of religious rite for the solemnization of the marriage is required. It shall be necessary, however, for the contracting parties to appear personally before the solemnizing and declare in the presence of not less than 2 witnesses of legal age that they take each other as husband and wife. This declaration shall be contained in the marriage certificate, which shall be signed by the contracting parties and their witnesses and attested by the solemnizing officer. In case of a marriage in articulo mortis, when the party at the point of death is unable to sign the marriage certificate, it shall be sufficient for one of the witnesses to the marriage to write the name of said party, which facts shall be attested by the solemnizing officer. Legal separation. Under Title II of Philippine Family Laws, a spouse can file for legal separation in court if the other spouse is sentenced to jail for more than 5 years, physically abuses her or a child in the household, or attempts to marry another person. Legal separation is allowed if one spouse has a drug or alcohol problems or is homosexual. Adultery or aggressive attempts by one spouse to get the other spouse to change religions, adopt political views, or prostitute herself or a child in the home are also grounds of legal separation. If one spouse leaves the other spouse without having a reason held as valid by the court, the abandoned spouse can file for separation after a year has passed. The spouse must file within 5 years of the qualifying event, and the court can deny the petition for various reasons, including evidence by the filing spouse consented to the qualifying event. Voided marriage. Articles 35 to 38 set the conditions that void an existing marriage. All marriage between persons under 18 are automatically voided by law, as well as a marriage performed by an unlicensed official. However, if at least one of spouses believe the official had authority, the marriage is still valid. Polygamous, bigamous, and incestuous marriage are invalid. If one spouse was incompetent at the time of the marriage, but his condition didn't present itself until after the ceremony, the marriage might be voided on those grounds under Article 36. Considerations. According to Article 46, fraud that can lead to annulment includes a spouse who hid a drug problem, an alcohol addiction, homosexuality, or a sexually transmitted disease. Deception involving chastity, money, station in life, or moral character isn't grounds for annulment under fraud. If a person remarried because she believed her prior spouse was dead, the bigamy void might not apply and the second marriage could be upheld. The prior spouse must be absent for at least 4 years for the second marriage to be valid, but only 2 years is needed if there's reason to believe he's dead, such as an accident. To preserve the marriage, if the missing spouse reappears, the remarried spouse must also have had the first marriage declared annulled or voided in court during the prior spouse's absence. Article 213 places a custody stipulation on legal separation cases. Unless the mother is an unfit parent, she receives custody if the child is under. Otherwise, the innocent spouse or the spouse who filed for separation gets custody providing she is fit. Annulment. Article 45 of Philippine Family Law establishes the allowable grounds for annulment. A marriage can be annulled if one spouse wasn't mentally sound at the time of the marriage or was forced into it, unless she continued living as husband and wife after regaining mental competence or the threat of force disappeared. Fraud on behalf of either spouse when agreeing to marry is grounds for annulment, as well as the discovery of an incurable sexually transmitted disease or permanent impotence. If either spouse was over 18 but not yet 21 and got married without parental consent, the marriage can be annulled if the parties no longer live together as husband and wife once the spouse turned 21. Annulment on the ground of mental disability. If a husband or wife was mentally disabled at the time of the marriage ceremony, the other spouse may be able to file for an annulment on the grounds of mental incapacity. The legal requirements and procedures for annulment are defined by the laws of the state in which the couple resides. If state law does not recognize mental disability as justification for an annulment, other grounds may need to be established or a divorce may need to be considered. Annulment of marriage due to abandonment. Abandonment by a husband or wife often causes emotional, financial, and legal stress. The abandoned spouse may want to know whether abandonment can result in an annulment of the marriage. Although abandonment generally does not serve as grounds for annulment, an annulment may be possible if the abandoned spouse can establish other grounds to invalidate the marriage. In addition, spousal abandonment or desertion may become grounds for divorce.